In the District Court of the 7th Judicial District of the State of Idaho and for the County of Fremont, State of Idaho plaintiff versus Lori Noreen Vallow, aka Lori Noreen Daybell, defendant, case number CR 22211624. Verdict. We, the jury, duly impaneled and sworn to try the above entitled action, for our verdict, unanimously answer the questions submitted to us as follows. Question number 1. In regards to count 1 of the amended indictment, is Lori Noreen Vallow not guilty or guilty of conspiracy to commit first-degree murder of Tylee Bryan and grand theft by deception? Answer, guilty. Question number 2.
As you know, Lori Vallow was convicted on the 12th of May 2023 for the murder of her 2 children, Tylee Ryan and JJ Vallow, as well as the murder of her husband's first wife, Tammy Daybell. Since her conviction, she has been slammed with additional charges in Arizona. First one was the murder of her husband, Charles Vallow, and the attempted murder of Brandon Boudreaux. Her husband, Chad Daybell, is currently in jail and has since been awaiting trial for the same murders. Nate Eaton, with the East Idaho News, went over a 3-page court document from the 2nd of June, and on the 15th, Lori Vallow appeared in court to find out if her previous trial would get thrown out. So obviously, there has been a lot of developments on the Doomsday couple case. So what's next for the Doomsday couple? Join us as we highlight the updates. Remember that sometime in August 2021, Chad Daybell waived his right to a speedy trial. His attorney, John Pryor, requested that the trial be held in June of next year. He cited the reason that some of his experts would be unavailable until that time. The judge filed a notice of trial setting on the 2nd of June. During this trial setting, the judge declared that Chad Daybell's trial would begin on the 1st of April 2024 and is expected to finish on the 31st of May 2024, assuming it would run that long. As you can imagine, this could mean a lot of things. We expect that a lot will happen before the trial actually begins. In cases like this, the judge usually lays out some deadlines for both parties involved. First are the pre-trial motions of the defense and prosecution. These motions would detail what each party intends to argue or what they do not want to argue during the trial, and these motions are expected to be filed before the trial commences. All discovery, in this case, any evidence of value, is also expected to be wrapped up and served on or before the 1st of February 2024. According to the 3-page court document, there is also expected to be a pre-trial conference on the 22nd of February at 9:30 a.m. This will likely be the last pre-trial opportunity for both attorneys to get together with the judge. If both the prosecution and the defense have no objections, then the trial will hold as planned. In this case, the defendant, Chad Daybell, is expected to be present at this pre-trial in Fremont County. If there are any plea agreements between now and April, they are expected to be reduced to writing, dated and signed by the attorneys for both parties and by the defendant, Chad Daybell, before it is taken to the judge. That is, if Chad does decide to take a plea agreement. If you really think about it, Chad has some decisions to make in the following months. His attorney, John Pryor, said he would prepare a transcript of Lori Vallow's entire trial that would be taken to Chad in jail. We're not sure if this has been done at this time, but Chad is expected to read about everything that happened in Lori's trial in preparation for his own. Another interesting point raised in the court document is the issue of the defendant's mental health. Just like we saw in Lori's case, a written notice must be given at least 90 days in advance of the set trial date if any party intends to raise any issue of mental concern. We believe such a call for an expert witness concerning any mental issue would most likely be raised by the defense, which is John Pryor in this case. It is very unlikely that this would even come up because up until now, there's been no talk of Chad having any mental illness.
I don't think that's going to be an issue in this case. There has been no talk of Chad's mental illness, if he has any, or his mental condition. It was much more of an issue in Lori's case.
A proposed jury questionnaire is due to the court by the 5th of January. It will be a closed, sealed hearing like what we saw in Lori's case. The defense would submit possible questions that they want to ask the jurors. These compiled questions are answered by a large number of potential jurors with the intention of eliminating some candidates who do not meet the juror requirements for this case.
The jurors, they compile these questionnaires, and then like in Lori's case, it'll go out to 1,500, 2,000 people. They'll bring the questionnaires back. They'll eliminate a group of them that way. If they say, yeah, I read everything Nate Eaton ever wrote about this trial, they're going to be eliminated. If they don't know anything about this trial, they could get called to the courthouse.
Also related to this are the proposed jury instructions. Now, this is expected to be submitted to both parties and to the court by 5 p.m. on the 11th of March. Along with that should be a list of exhibits and witnesses.
Mine is you've got January 1st if Chad intends to do any sort of mental illness. If it's going to be discussed in the trial, you've got that. After January 1st, come February, you've got the deadline for all discovery. That's on February 1st. February 22nd, there's the final pre-trial conference, which is a court hearing where they all get together. And then on March 11th, the final list of witnesses and exhibits and jury instructions, proposed jury instructions, are due. That's go time.
So what can we actually expect between now and when this timeline kicks off? Well, both parties will essentially be preparing for trial. Defense attorney John Pryor will go over all the evidence and go back and forth with Chad Daybell to build what they could consider a solid case. We also expect that there may be a few hearings between now and December, or at the very least, a couple of motions would be filed by the defense. Then there is the issue of the camera ban during this trial. The ban by Judge Boyce is still to be in effect. However, we expect that it might be brought up for the judge to reconsider allowing media outlets to live stream the trial via the court's cameras or their own. The released footage from Lori's verdict was covered by the court cameras, so naturally this would be requested sometime soon. While we are on the topic of Lori Vallow, we can say that she has some busy days ahead. Next on the agenda for Lori Vallow Daybell is her sentencing, which is scheduled to hold in July. Her pre-sentence investigation is currently underway. They are most likely going through everything again, maybe a little more this time. They are investigating everything about Lori's life, gathering and putting together accounts from people who have known her for a long time. Unfortunately, the results of this extensive investigation are going to be sealed.
They are sealed. These reports are sealed for life. What will happen is this investigation will be done, it will be given to the judge, it will be given to her attorney and the prosecution, but it's sealed forever. Unless somebody leaks it to us or gives it to us in those parties, we won't get one.
This pre-sentence investigation will include a detailed description of the situation surrounding the criminal activity, as well as the defendant's version of the crime committed. That is assuming Lori Vallow decides to talk to the investigators. If she does, there would finally be a first-hand account of how it all went, or at least how she thinks it went down. The investigation should also contain reports of the arresting officers and the victim's version of what happened. Of course, that is not possible as the victims of the Doomsday couple are no longer with us, all except Brandon Boudreaux. Also to be considered in her pre-trial investigation is her criminal record prior to the crimes, which we believe is squeaky clean up until Lori met Chad Daybell. Next, her social history. This would include her age, past marriages, educational and employment background, interests, and health status.
Results of any substance abuse evaluation, mental health evaluation. That will likely be a big part of Lori. Domestic assault and battery evaluation, a psychosexual evaluation, and then the pre-sentence investigator's analysis of the defendant's condition.
The pre-sentence report is also expected to include a complete summary of pre-sentence investigators' view of all psychological factors surrounding the commission of the crime. The investigator is also expected to include an analysis of a specific recommendation regarding a psychological examination and a plan of rehabilitation where necessary. For those who do not know, this pre-sentence report is pretty much a standard procedure. Whether it's theft or murder, this report will be done no matter the crime. But of course, there are different levels at which a judge can reference them. In cases where the pre-sentence reports indicate that the chance of reoffending is very low, the judge may go easy on the defendant. But for cases where the report raises some major concerns like a high risk to reoffend, the judge will most likely take this into consideration. Notably, Lori Vallow still does not qualify for the death penalty, but we cannot say the same for Chad Daybell. As it stands today, Chad faces the possibility of a death sentence, so we expect that the jury selection for his case will take much longer than it did for Lori's case. While the jury selection for Lori Vallow took about 4 days, that of Chad will run longer because the jurors need to be asked many more questions about their views on the death penalty and the sanctity of life.
Defense will not want someone who says, yeah, I believe everyone should be put to death. They're not going to want that. The prosecution's not going to want someone who says, I am adamantly opposed to the death penalty on all counts. They're going to try to find people who are in the middle.
Based on the statistics, if Chad Daybell does get the death penalty, it could be decades before his life would be taken. In cases like this, we have seen death row convicts spend decades trying to appeal their sentence. There are also a lot of bureaucratic processes that the state must follow to make sure that only the worst of the worst actually face lethal injection or whatever means of execution is dealt with. The death penalty is worse than the life sentence, not just because such a convict may lose his life. You see, inmates on death row are actually isolated and can spend more than 2 decades alone in a tiny cement room with very limited communication from their families. Because of the severity of the death sentence, we imagine that between now and his trial date in April next year, there would be a lot of talk about plea agreements in the Chad Daybell case. We mean now that Laurie has been found guilty, we might see a difference in what Chad may be willing to plead to. There is also the fact that the prosecution has always had a lot more on Chad than they did with Laurie, so we expect that he may settle for some sort of agreement. The prosecution may also be willing to negotiate with some things, such as taking the death penalty off the table for Chad or dropping one of the lesser charges like the insurance fraud if he cooperates.
We'll drop the insurance charges, he gets life in prison. Or maybe we drop the conspiracy and he just pleads on the murders.
These are hypothetical situations that could play out between now and the 1st of April. Laurie can choose not to cooperate with this pre-sentence investigator, or she could talk to them. It really is of no consequence because the investigation will be done regardless. The report will be submitted to the judge a few days or a few weeks before the sentencing date, which is currently set for the 31st of July 2023 at the Fremont County Courthouse. The sentencing will be live streamed, so you can expect that we will be back with updates from the sentencing. Obviously, Laurie Vallow will be present in court, but the direction her attorneys intend to go with her defense is left to be seen. They could argue that Laurie should get probation as a result of a mental illness or something along the lines of that.
Attorneys will argue what they think she should get. They could argue for probation. They could argue that she's mentally ill, that she shouldn't go away for life and she should get probation.
On the other hand, the prosecution would definitely argue for the life sentence. JJ's grandparents, Larry and Kay Woodcock, may take the stand to deliver a victim impact statement. They get to look Laurie in the eyes and say whatever they want for however long they want.
You can imagine Kay and Larry have probably waited 4 years. What would you say to the person who killed your grandson and his sister and is accused of killing your brother, Charles Vallow? What would you say?
Similarly, Tammy Daybell's children could also make a statement as victims in this case if they wanted to. Notably, they weren't present for Laurie Vallow's first trial, but they may have a different stance now. It is also possible for Tammy's family to make a written statement instead, one that would be addressed to the judge. This may mean that their victim impact statement would not be made public, and in such a case the judge would simply just read and consider it in his sentencing. Whatever the case may be, they do have that choice. Laurie will most likely be offered the chance to say something by the judge. This is a fascinating prospect that we know a lot of people would be looking forward to. In situations like this, it's common to see the defendants apologizing, sobbing, or giving this aura of remorse. But Laurie seems like the kind to maintain a straight face no matter what is being said. Would Laurie Vallow speak up, or would she resort to her blank and emotionless look? We would all just have to wait and see. At this moment, Chad must know all that happened to Laurie during her trial. If not in detail, then at least the highlights of it. We believe he is already preparing his own defense with his team. Just like Laurie, he also has not shown a lot of emotion throughout this process. The defense team will equally be busy building their case at this point. From the highlights of Laurie's case to the witnesses available, there is obviously a lot to cover for this case. Looking back, there were about 60 witnesses during Laurie Vallow's trial, so we believe there would be at least many for Chad's case. It could even be more than that, because the death penalty is still on the table with Chad. As seen in cases with the death penalty, if the jury finds Chad guilty, then the defense will argue why he should not die for his crimes. To do this, they would need to put forth additional witnesses to testify in his favor. On the other hand, the prosecution would argue that Chad deserves capital punishment, so this back and forth process will require additional witnesses to take the stand. Besides the number of witnesses, this would also add to the time of the trial. After the prosecution and the defense have made their arguments on the death sentence, which could take another week of testimony, the jury would have to sit and then come back to whether or not Chad should face the capital punishment. One question a lot of people have at this point is why the death penalty was taken off for Lori Vallow but not Chad Daybell. It was mostly just a matter of technicality, because in the beginning the death penalty was on for both of them, and if you recall, the doomsday couple were actually being prepared to stand trial together. That would have been interesting to see, but somewhere along the line Chad waived his right to a speedy trial while Lori did not.
In court documents filed yesterday, Daybell waived his constitutional rights to a speedy trial.
At that time, there was a lot of last-minute evidence that came in. The mitigation specialist assigned to advocate on Lori's behalf told the judge there was not enough time to review all of the new evidence. A mitigation specialist is someone who plays a key role in advocating for a fair sentence after conducting a thorough report on the defendant's life story and circumstances. No matter the crime, everyone has a right to a fair trial. So that is what a mitigation specialist handles, especially in death penalty cases. At this point, you could say that the judge was running out of options. Since the mitigator was not going to be ready for trial, Judge Boyce had the option of pushing back Lori's trial, but doing so would have violated her right to a speedy trial, which is supposed to happen within 6 months of arraignment. But that did not happen, and Lori's case was already past the deadline. Another thing the judge had to consider was the fact that the further the trial gets pushed back, the greater the chance that it gets thrown out on appeal. So it was either to drop the death penalty and proceed with the trial, or push the trial back if Lori was not going to waive her right to a speedy trial. This was why Lori's case took off and was severed from that of Chad, who had his case pushed back. In the end, it was a win for Lori simply because she did not waive her right to a speedy trial. Most recently, a hearing was held on the 15th of June at the Fremont County Courthouse. Lori Vallow was present in a jailhouse uniform.
She was smiling. And there she goes.
This hearing is related to the motion filed by Lori's attorneys to throw out the guilty verdict. Remember that Lori Vallow's defense attorneys, Jim Archibald and John Thomas, had filed a motion for a new trial to be conducted for Lori Vallow on the grounds of juror misconduct.
And we do have some breaking news out of the Doomsday Cult Mom murder case. Attorneys for Lori Vallow Daybell have filed a motion for a new trial. Now, in the filing, Daybell's attorneys claim the following. The court misdirected the jury in a matter of law as it related to the jury instructions on conspiracy. 2, the court misdirected the jury as a matter of law as it related to the amended indictment. And 3, a juror interview revealed that the jury instructions were confusing and that juror, there was a juror who did an interview, knew of evidence not submitted to the jury. All very serious issues. Now, the filing cites an interview that the juror number 8 did with East Idaho news reporter Nate Eaton following Daybell's conviction.
Cameras were not allowed in the courtroom, but the audio was made available to the public. As you can imagine, the defense first highlighted the reasons for filing the motion for a new trial. After that, the defense stated that if the motion is denied, they would prepare for the sentencing and an appeal going forward. But if the motion is granted, the defense expects that Lori's case would be combined with that of Chad Daybell to hold next year.
With those issues, Your Honor, if the court denies this motion for a new trial, of course we'll proceed to sentencing, and these issues can be taken up on appeal. If the court grants this motion for a new trial, we would expect that our cases would be combined with Chad Daybell's trial next year.
The defense emphasized that they never asked for the trials to be separated in the first place, so they would be happy with that outcome. The hearing ran for almost an hour, during which time the defense and prosecution laid out their arguments. In the end, the judge did not find any of the evidence submitted to the court to be sufficient enough to throw out the first trial of Lori Vallow. For that simple reason, the motion for a new trial was denied, and the court is to proceed with the sentencing on the 31st of July.
Early the motion for a new trial as it relates to those statutory grounds, and I don't find any sufficient evidence has been submitted to the court allowing for a new trial to be granted. For that reason, the court is going to deny the motion, and the court will proceed on July 31st with sentencing in the case.
So what's next for Lori Vallow? We expect that there will be an appeal from the defense. Her attorneys have made that clear. But if nothing comes up in the following weeks, Lori's sentencing will be held next month. In preparation for that, the judge has issued a 7-page order that clearly indicates the persons that can qualify as victims to take the stand and give their impact statements during the sentencing. This essentially emphasized that only immediate family members are allowed to take the stand for statements.
Immediate family member consists of, in the eyes of Idaho law, parent, mother-in-law, father-in-law, mother, father, husband, wife, sister, brother, brother-in-law, sister-in-law, son-in-law, daughter-in-law, or a son or daughter.
For now, we would certainly hear from JJ's grandfather, Kay Woodcock, Lori's sister, Summer Shifleft, and Lori's son, Colby Ryan. With the date of the sentencing fast approaching, there is a lot to look forward to in the Lori Vallow case.